There we are. Hi, Todd Phillips, RE Journals. We're here in our Breaking Through the Disruption series, webinar series. Today we're talking legal topics, force majeure, and potentially how documents are altered by the events of the last few weeks. I have gained a new appreciation for newscasters who can stare into the camera and not the picture. So thank you for joining us. I'm going to go through a couple of housekeeping items quick as we let people log on. I see we're up around 200 so far. Keep going as we get up here. This is us. We are the parent company for Red News. We publish 6 different publications in 17 states. We were scheduled to do 104 live events this year. Some of that's been put on hold or delayed, but we are doing as many webinars as we can, up to 2 a day. Been going strong for 2 weeks, and we'll keep going. So we'll continue to try to bring you the information you need. Special thanks to Wilson, Cribbs, and Goren, our sponsors today. Also, the 2 attorneys that are with us are from the same firm. Let me get us out of the corner there. If you have connection issues, I don't expect to have much on our end. I'm showing 4 or 5 bars signal from our participants or from our speakers. But on your end, you may have some connection issues. If you do, if somebody freezes up, if their voice stops, if it goes blank, there's a button on the top, push reconnect. That's the best way to refresh it. And a lot of people say it just happens instant and you're fine to keep going. If that doesn't work, make sure you're using Google Chrome. That's been the best browser to use. If that doesn't work, then just close your browser down and restart again and give it another try. On the right side of your screen, if you're on a computer, below you if you're on your cell phone, you'll have a chat function. This is where you want to pop in right now and enter your name, state if you want to, and company you're with to network with other people. If you want to put your contact info in here, that's just fine too. We're okay with that. You also will see polls. So I put a poll up right now. This one's pretty relevant, and I'm glad I got some fun answers so far. I pigeonhole you into 1 or 2 answers. Sorry. True or false? I knew what force majeure meant prior to March 16th, 2020. And so far, 75% of the people said yes, of course. Were the rest of you living under a rock? And 24% now are said no, I had no idea. We'll see how honest people are and what that gets up to by the end. But let's dig in. Introduce our speakers. Hold, please. Scot Clinton, senior attorney, Wilson, Cribbs, and Goren. There's his contact info if you need it. Scott's knowledgeable in contract, tenant law, tenant and landlord law. And we've got David Groff on the line, shareholder, Wilson, Cribbs, and Goren, who's versed in a whole lot of things, he told me. So he'll take any question you can kind of get, seeing if he's paying attention. All right. Well, Scott, do you want to jump in and start with a slideshow presentation? Does that work?
Sure. I guess just by way of background, regarding our firm, we're based in Houston, Texas, 20 attorneys, 17 transactional, 3 litigation, and our focus is commercial real estate and all the gamut of issues that fall within that scope. A number of our attorneys are board certified. And our experience covers really a wide range of asset types and practice groups. So we appreciate the opportunity to be able to discuss and sort of share what we have been seeing out there on these issues, and particularly when it comes to the issues of force majeure clauses, especially in lease texts that we've seen. So I think just with that general backdrop, David, unless you had any additions you wanted to make, we could move into the PowerPoint.
No, I think that's fine. I think also in these unprecedented times, we're receiving a lot of phone calls from clients and also talking with other lawyers in our region, trying to share some experience on what they're seeing, some reactions they're getting, perhaps some claims and arguments for both landlord and tenant side. So really, I think a lot of this focus today will cover real estate in general with a concentration of attention to leasing arrangements. Certainly prepared to talk about purchase and sale agreements and perhaps some mortgage information, lender issues as well, to the extent anybody has some questions like that. But really, I think the primary focus is going to be on the leasing side.
And we sort of I think our thinking behind our presentation today is really to try to start with a 30,000 foot level view of kind of the big picture on issues of force majeure and the intersection that force majeure and contracts are meeting when it comes to the COVID-19 coronavirus pandemic and sort of ripple effects from that. So with that in mind, we start from one quote of many from courts that are handling issues. This is just, somewhat a statement of, in respects, the obvious, that we're in the midst of what is in many respects an unprecedented pandemic that is global, that is, again, the ripple effects are seen and felt in our schools, jobs, professional sports, and life in general. That's a quote from a recent memorandum order having to do with prisoner issues, which is one area of law where a lot of these issues are being seen. So, big picture again, force majeure is going to be, is the concept and provisions are going to be pop up most oftentimes in leases, and the idea, the gist is to identify specific types of events, categories of events that will relieve parties of their obligation to perform. In Texas, the general method and approach to interpreting force majeure clause, if there is one, really does boil down to the actual terms of the clause. Now, there are common law concepts, sometimes referred interchangeably as impossibility of performance, also sometimes similarly at the same time referred to as impracticability or commercial impracticability. Generally speaking, the way that courts will interpret these and the way that parties will interpret these is again focusing on the specific terms. In the event that there are vagueness, terms are vague enough, courts may turn to the common law in order to use what are called gap fillers. But generally speaking, the reading is going to begin and follow the terms of the clause itself. Moving forward, just as an example of a clause, and this is something out of a recent court case out of the Western District of Texas, a lease agreement being defining a force majeure event as, quote, any delay due to strikes, riots, act of God, shortages of labor or materials, war, governmental laws, regulations, or restrictions, or any other causes of any kind whatsoever which are beyond the reasonable control of such party. You see there a good example of some general categories of events that are identified and followed at the end by what we'll refer to and discuss a little bit later as what's called a catch-all provision, beginning with the language or any other causes of any kind. Again, what you'll be seeing or we'll be discussing and I think covering throughout is that there are any number of iterations and versions of force majeure clauses that are out there, due in large part to the fact that they are negotiated between parties or may be altered or modified depending upon the circumstances of the parties. So, generally speaking, again, just big picture bullet points. As we've already noted, if there is a clause, and there are courts approach these situations firstly depending upon whether or not there is a clause. But if there is a clause, again, the specific contract language itself is really the key. That's going to be really where the analysis and the scope and the application is going to be determined. Quoting from a recent case out of the Houston Court of Appeals, which is a common thread throughout the case law, at least in Texas, is that the scope and effect really depends upon the specific language not necessarily on any traditional definition of the term. And that's sort of an interesting backdrop, because there are courts that do teach that the term force majeure is one that in a lot of respects lacks definition for that reason, because it is so much dependent upon how the parties have negotiated and come to agreement on what that term is in their contract. And so close review of the specific terms that you may have or analyzing is really, really key. We can't underscore that enough, because as you can imagine, different drafters and negotiations may come out with terms and scope that even if there are small tweaks in the language, that can really have significant effect for what that means for the application and the scope of a force majeure clause. So we've already seen in the sample clause that we cited that there can be a number of different categories, but there's usually some common categories that one might see depending upon the circumstances. For example, as we list here, you will sometimes there may be an epidemic or pandemic clause. More commonly, as we've already referenced, will be categories that have to do with government action or law or regulation, perhaps having to do with labor or material shortages, acts of God, any number of different categories along those lines are kind of what you might consider or see oftentimes as common categories or terms. And then again, oftentimes followed by a catch-all provision.
Hey, Scott and David, we're getting a lot of background noise right now. Does somebody have something on? Either of you two? Or
Nope.
I'm gonna try turning your mics down quick, one at a time. Well, there it stopped.
Okay.
So
Great.
I'm just gonna log back out again. You keep going.
Okay. Thank you, Todd. So again, just to reiterate that there's a lot of times that you may probably start with the expectation and probably see perhaps some commonly used terms along these lines. That then the question you'll start to then get to is where the rubber meets the road, and what does that mean for what those terms mean and whether they apply in situations like this. Force majeure clauses that may reference epidemic or pandemic are seen, in my view, relatively rarely. Actually, I think perhaps in healthcare fields or things along those lines. But I don't know that I've seen any in the leases that I've looked at. David, is that?
Yeah, I'd agree with that. It's been conspicuously absent from a lot of the form lease language that I've seen and that I've even used over the last however many years. But you can bet that moving forward, the word epidemic or the word pandemic, government shutdown in response to either of those or something similar are going to start being infused into everybody's force majeure language moving forward. But that doesn't necessarily and doesn't at all actually affect a lot of the leases that are currently in place today, where tenants are trying to exercise their rights or purported rights under a force majeure clause. I just want to point out and remind people that this is all relatively new to so many people: landlords, tenants, lawyers, bankers, everybody. And information changes on a daily basis. So there has been an excessive amount of uncertainty that probably derives from panic, and justifiably so. But positions change as frequently as the data that people receive through their news outlets on a daily basis. So negotiations and arguments that may have been made by landlords and tenants several days or even a week ago probably aren't continuing today. They're changing the ground as the rules of the environment are changing. So are the rules of the negotiations. But I want to mention, I'm pretty sure everybody knows that force majeure is not a get out of jail free clause. It's not a card that you can play to get out of your lease. It merely is a mechanism to delay a performance when there is something occurring that's specifically allowed in the lease to defer performance until that interruption is removed. So any thoughts about I can terminate my lease because there's a pandemic probably isn't going to be workable. Although there may be some leases that claim if the force majeure event continues for a stated period of time, maybe in excess of 30, 60, 90, 120 days, then there may be some express language allowing a termination of a lease or a contract or whatever. But absent that language, it is merely just a deferral of performance until the interruption is removed. And I think a lot of people are losing sight of that based on the panic that we're all experiencing in the marketplace right now and have been for 3 weeks. So I just want to make sure we're all thinking about that still.
And David, I think to one of the first points that you made, certainly at least based on research into how the courts are starting to take on issues, generally speaking, related to coronavirus, COVID-19. There's really not much in the way of guidance when it comes to the lease issues or things along those lines. It's all tackling issues, as we mentioned from the top, related in large part to prisoners and really the cutting edge of kind of healthcare or health issues relating to, for example, compassionate release of prisoners, things along those lines. There's no guidance yet, specifically where that intersection of contracts and leases and with respect to epidemic, pandemic in this time period of coronavirus or COVID-19, and also to your point about the remedies that folks may be thinking about and wondering about. You're spot on that usually you're going to someone looking at a force majeure clause is going to need to be looking at the remedies in specifically to see whether or not they provide some guidance or what kind of options they may present, even if a force majeure clause does apply. Have you seen many, if any, that expressly allow for termination within those provisions themselves? I don't think I have at this point.
Yeah, there have been very few. Typically, a force majeure clause in the past has been something that a lot of people don't pay much attention to. It's kind of one of the boilerplate paragraphs towards the end. It doesn't mean that it's any less important than any other provision in the lease, but it sometimes does not get the attention it requires because people have been so comfortable for so long that there won't be a war, there won't be an insurrection, or hurricanes we can get insured. And
it looks like David may have frozen up on my end.
Am I still there?
Looking good from here. You're still good. You're still broadcasting.
Todd, are you there?
Yeah, can you hear me? I think it's your computer, Scott. If you can hear me.
I'm going to assume y'all may be able to hear me, so I'm going to at least move into trying to address situations where, assuming that a force majeure clause doesn't expressly provide for epidemic or pandemic or address issues along those lines, are there any other options available? For example, in force majeure language that may include a provision relating to government action, law, or regulations. There have been instances when Texas courts have tried to address the scope of those. One of them is on the slide in front of us, an instance in a case called Majeure versus Jetstream Investments, where the Texas Railroad Commission had ordered a lessee to cease production. In that instance, the court paid some attention to the fact that the lessee could still have complied with the regulation, obtained financial assurance, forms of financial assurance were available, and so the court could have held that the force majeure clause did not protect the lessee. Looks like I'm frozen.
If you can hear me, we can still hear you. David, can you
Similarly, there are other cases
There we go.
again, and I think the common theme of at least some of the cases that address government action or law is that they are more specifically, usually they're cases that have to deal with government laws or regulations that are really focused on the specific party itself. The party, perhaps, that is trying to invoke the force majeure clause. Looks like y'all can hear me, so I'm going to continue proceeding along these lines. So it's, I think, at the very least, it's probably unclear whether a government law or regulation is going to be, in and of itself, considered sufficient to reach the type of situations that we're seeing here, where certainly by no means do we have, or we're not seeing orders from either the federal, state, local level that are specific to individual parties at this point. That's not to say that they're not out there, just that courts haven't, grappled quite as clearly with issues where the government order or regulation is more broad. We just don't have quite as much guidance on those particular types of points. So with that being said, then what other types of what else can we learn in terms of other types of clauses that might have application? A lot of times there's going to be questions about act of God. Is that something that is going to provide enough scope and application to situations like this? And as we reference in the slides, the courts, in some respects, grapple with this. This is a difficult issue in some respects. The case called Foster versus Lecomte teaches that the term "act of God" it is defying, lacks a precise legal definition. It's generally considered involving forces of nature, hurricanes, for instance. And a common thread is, though, that it is usually going to be tied to some kind of force of nature along those lines. Now, what is also interesting, what we have learned from some of the cases that at least arise out of negligence claims, is that events may be considered acts of God when they occur exclusively due to the event itself, the violence of nature itself, which begs the question then as to whether or not and Todd, if you have the ability to restart the PowerPoint, that might help everybody. I have it in my materials, but if you're able to, that would be great. So again, what that teaches us is that, even act of God provisions may not be, it's not as clear whether they're going to apply here because there may be, the analysis may go into whether the force majeure event is having expressly directly to do with, in this instance, the pandemic itself, or whether it's related to other issues that are within the series of events that maybe are affecting the ability to perform. Then, as we pointed out before, a lot of times you're going to see in a force majeure clause what's called a catch-all provision. And you'll recall we quoted from one earlier. And generally speaking, that catch-all provision is going to, like it sounds like, it's going to try to address other circumstances that may otherwise hinder the ability of the parties to, or the party to perform. There's two things that we think are especially pertinent to these catch-all provisions. One is that it's called a doctrine called justum generis, and certainly has import in Texas courts and cases, and presumably may in other jurisdictions. The idea is that if there is a catch-all provision, that the list of items and categories that are discussed in the categories of events that are described in the preceding portion of the clause, whatever may follow after that, the catch-all provision is going to be limited to things like the former. The initial list is going to sort of lay out the parameters of what's going to be following after that, and we cite to a case that establishes that proposition. So, which sort of raises the question, if we think that we're looking at a force majeure clause where where maybe we don't have a good fit for the current circumstances regarding coronavirus, then what about the overall economic hardship, the overall impact that the pandemic is having on the economy generally and on businesses in particular? And here, again, there are some cases and case law that teach us that, generally speaking, that in and of itself is really not going to fall within a catch-all provision. The idea being that the financial difficulties, economic hardships, that in and of itself is not going to excuse performance. In Texas, a lot of the cases that we've seen, a lot of times they have to do with the oil and gas markets, and cases where the courts are examining what's referred to in the slide in front of us as economic downturns in markets. And courts, again, they oftentimes are going to use this justum generis doctrine, as well as holding that economic downturns in markets are not necessarily are not considered unforeseeable. They have or at least occur regularly enough that those are not going to be considered unforeseeable. Now, is what everyone is going through currently, is that similar to, is that going to fall within the scope of an economic downturn as previous cases have decided? We don't know yet, but that's what at least we've seen when these types of issues have been considered before. Another interesting sort of area that we've looked at and considered is, well, what about in previous economic crises? For example, back in 2000, beginning as seen in 2008, and again, the general common thread of cases in the wake of the 2008 financial crisis was, generally speaking, that the financial hardships that parties were falling under and experiencing in and of itself was not going to be sufficient either under force majeure provisions or even under alternatively some of the common law doctrines in order to excuse performance. That is, I think, at least as far as we have been able to determine, seems like a fairly consistent thread throughout courts, with a few exceptions, as we note. There are cases where, at least under more common law impossibility and practicability doctrines, there were determinations that economic factors might be sufficient. But again, a lot of those we're going to fall back to or depend a lot upon the specific scope in terms of the force majeure clause. And as I mentioned before, part of what courts are looking at least in Texas, is this issue of foreseeability or unforeseeability, and whether or not the events were foreseeable or not. There's an interesting sort of discussion that seems to be arising about the extent to which, on the one hand, coronavirus, COVID-19, and its effects are truly distinct, unprecedented, while at the same time considerations that there have been other types of epidemics, pandemics. The 2009 H1N1 pandemic, which had significant impact and sickness and death in the United States. 2003, the SARS epidemic. And so interesting questions as to whether or not at some point, whether courts may look at those types of issues and think that issues of pandemics or epidemics are, or going forward, maybe foreseeable, and ones that parties should be more expected to more actively negotiate. In this instance, other additional and we think interesting sort of questions that are arising out of this, and that other commentators certainly have pointed out as well. If we just even assuming for the sake of argument that that there has been a force majeure event, depending upon the scope of the clause, when did it begin? How are we to make that determination? And as we all know, there's a significant number of different touch points that one could point to. The January 30th, 2020 declaration of public health emergency by the World Health Organization. January 31st, the Health and Human Services Secretary declared public health emergency. March, declarations of national emergency and disaster proclamations, so on and so forth. Here in Harris County, in Texas, on March 24th, a stay-home order issued by the Harris County judge, which even more specifically was applying these limitations on social gatherings and things along those lines. So, when did that event begin, and what does that have? What impact does that have on the remedies that a party may want to seek if they believe in good faith that they do have that a force majeure event has occurred? Even further along those lines, another important question for parties to be thinking about when they're looking at these terms, and this goes back to a point that David mentioned earlier, is, well, when does it end? Generally speaking, a force majeure event is not going to last into perpetuity. There's going to be a beginning and an end. There's, at least in our view, we haven't seen quite so much guidance on this, although one case that we mention and note, it does arise in the context of a government action when a Bureau of Safety and Environmental Enforcement had imposed a drilling suspension order, and the lifting of that order did in fact constitute, or was recognized by the court in that instance, as considering a lift and an end to the force majeure event. With that, and as I think as we mentioned already, there are some of these common law principles that are somewhat that present the backdrop for how parties may be looking at the impact of COVID-19, even if there's a contract that lacks a force majeure clause. As we mentioned at the start, some of these concepts referred to as impossibility of performance or impracticability, and in some instances, courts intertwine them. And so there may be an argument that pure impossibility of performance, that in fact that may not necessarily be the threshold that courts sometimes refer to these as impossibility or impracticability. That those are just ways to try to describe and define the overall doctrine that we're looking at here. And so with that in mind, I will take a pause. And David, if you have comments that you want to add, just now that we've laid out some of the big picture
Sure.
principles, please do so.
Sure. Thank you, Scott. I think just kind of, I want to go back over trod territory, but Scott's laid out some of the basic thoughts and legal background.
And for what it's worth, I'm not able to hear anyone right now.
We got you. Okay, I'm just going to keep going. We've covered some ground on what constitutes force majeure, some of the themes, they both in common law and interpretation of how those affect. So I'm not going to go back to those, but it's very important to go into your, for example, lease agreement or your contract or your loan documents. Read those provisions if you're interested in representing, or if you do represent somebody, or you're a party to a lease or a contract that's been interrupted in this time. Because really what's going to drive the argument is what your lease, contract, or loan documents say. I do know from experience over a number of years that in most, if well, not all, but a good number or an overwhelming majority of the lease contracts that discuss force majeure provisions or include them, there's often going to be found a carve-out that says specifically that force majeure will not apply in the case of a monetary obligation. So whether or not you have a force majeure, a hurricane, act of God, riot, insurrection, any of these other examples that are out there, in a good number of leases, there is not going to be an exception. In fact, there's an express exclusion from the operation of force majeure for the payment of rent. So again, you need to go back and look at your particular documents to what they say. As I mentioned earlier, I think a lot of form documents in the future are going to reflect the things and experiences that we're going through now. But for the ones that are already in place and the ones that are already in trouble, you need to look at the documents that you have. One note on the impossibility defense. I don't know whether there's been case law on it, and Scott, maybe you've come across it. I frankly don't know if it's ever been there before. Impossibility of performance is a broad topic, but what we're really talking about is not the impossibility of them to take the lease. It's the impossibility of certain retailers to sell product because they've been told to be closed. Restaurants to serve food, other business operations to have employees stay home. The performance of the lease is not necessarily the activity under the permitted use by the tenant. And some landlords would argue that the only obligation that the tenant has is to maintain, occupy the premises, and pay rent, and not violate the covenants under the lease. So I think if people are pressing impossibility defenses, perhaps they're going to be facing some challenges from the landlord saying nothing is stopping you from paying rent. A tenant going out of business is not excused from paying rent. That's just simply called default. In 2009, during all the Great Recession and banking fallout, liquidity, everything that we all remember, I do not recall an instance of a defaulting tenant who went out of business saying it was impossible for me to perform under my rent, under my lease, so I'm to be excused. I think these themes will be coming back up. We're still very early in the game. There's not been a lot of defaults declared yet. There have been a lot of late payments of rent. There have been a lot of letters written to landlords advising landlords that the tenants are not going to pay rent or attempting to exercise their force majeure rights. So we'll see how those kind of play out. But I wanted to bring up two other items that I think is getting lost in some of this. And this really affects the retail landlords and retail tenants out there. There are a good number of retail lease agreements that contain other clauses that could be triggered by one or more tenants in the shopping center exercising force majeure, whether valid or invalid. And the clauses I'm referring to, or at least the first one, is a co-tenancy clause. A lot of major tenants would require that the landlord maintain open and operating neighbors within the shopping center to support traffic and customer base and a variety of other reasons. If the landlord is unable to provide those co-tenancy requirements, a tenant may exercise certain relief if it has that clause under its lease. And some of the relief typically that's available in that instance would be a reduced rent, perhaps a free rent, perhaps a termination if the co-tenancy is not met for an extended and defined period of time. I've not seen any letters or heard anything from landlords or tenants suggesting the use of co-tenancy provisions, but I'm just letting you all know that that could be out there. It's certainly a possibility. And then you might find a landlord in the instance of having to exercise the force majeure clause instead of the tenant, because the landlord would say it's not my fault, beyond my reasonable control. Other tenants are closed and they've been ordered shut down, so my co-tenancy requirement cannot be met. It's an impossibility. So I think we're going to see a lot of things, a lot of both sides of the coin, which we really don't expect. And as this plays out, I think it's going to get very interesting. There's another clause in most retail leases. You don't see it so much in office and industrial, but in retail leasing environments, you may have a continuous operations clause. And under this clause, the tenant is required to remain open, fully staffed, fully inventoried, and operating within the premises for a set number of hours a day, set number of days a week, what have you. The landlord can treat it as a default if it's not met. Again, the landlord's probably in this instance wanting to do it. But the continuous operations clause may shed some light on the subject here. In a clear majority of the continuous operations clause, a landlord does not have to declare default or terminate the lease, but it can insist and demand that the tenant continue to pay its rent obligations even though it has gone dark. So be prepared, or maybe start thinking about arguments from the landlord side when a tenant says, I can't operate because I have no employees, I can't reach staff, I can't serve, and the government's telling me this and that. It could be treated nothing more or nothing greater than a go dark situation in which the tenant would otherwise be obligated to pay its full rent obligation under the terms of the lease without interruption whatsoever. Those are kind of thoughts that pop up. I have not seen specific use of any of those arguments yet, but they're certainly on the horizon. And I certainly anticipate that people will start considering them and using them in letters, perhaps back and forth, to try to arrive at some kind of agreement to get through the situation we're in. Now, I think it's a good time to point out some additional considerations that landlords may have at this time. Regardless of whether the force majeure clause is properly exercised, regardless of whether it's applicable, a good number of tenants are not paying the rent. And so the landlords are stuck in a situation where they need to figure out how they're going to get through this. And there are a number of considerations that the landlord's going to have to face. If the landlord has a mortgage on the property, the shopping center, the office building, the industrial park, whatever it might be, the landlord's going to have certain requirements under its loan agreement with its lender. And these things would require the steady stream of of debt service being paid to the lender. Rent interruption is going to certainly impact the landlord's ability to make timely payments under its loan. Now, we're only in about the third or fourth week of what's going on here. April 1st was the first fixed rent due date since the declaration of the emergencies and disaster and shut-in orders, and a lot of rent wasn't paid on the 1st. Landlords may have a cash backup and may be staying current with their lenders, but May 1st will be the test, I think, if the tenants continue to withhold rent payments and the landlords find themselves without sufficient capital to make good on their debt service. So the landlords are going to need to be very careful with what they do, probably should be talking with their lenders at this time, if they have not already begun so, advising them of the status and keeping them inside the loop of what's going on with their properties. At some point, the landlords may be requiring or requesting some kind of forbearance or delay or deferment from their lenders, and it doesn't do any good to go in and ask for that when you're already 3 weeks overdue on your second mortgage payment. So I think bringing them in early, letting them know they understand the situation, they're not living under rocks, they know what's going on, bringing them in, I think, would be a good idea at this time. Something else to point out, not all leases are the same. And we have a lot of different leases out there. You've got retail leases, you have industrial leases, you have office leasing, you have ground leasing long-term, you have national tenants, regional, local, mom and pop, sole proprietors. So not every lease is going to be the same. Not every interaction between landlord and tenant will be the same. Not every right of force majeure or continuous operations or other performance under the leases will be the same. Each negotiation has the potential to be significantly different than any other based on the particular circumstances of that event. With that in mind, and due to the size of the tenants, recognize that some tenants may have more leverage with negotiating than others, and that's another factor. How significant of a tenant is it to your shopping center, to your office project, to your industrial project, or whatever? There's just a lot of different things to consider. But when you put all these together, I want to try and give y'all some. Well, that's nice. I wanted to give some practical insight into some things that I've seen in the last 2 or 3 weeks as this has been progressing. Landlords and tenants, regardless of whether or not the force majeure is applicable, regardless of whether or not this event is a impossibility defense, landlords and tenants are trying to work something out with themselves to try and keep the things in place. And both sides really have different concerns when balancing any kind of negotiation or arrangement. I do believe that the landlord would be advised to send, upon receipt of a letter claiming force majeure, to send a letter out to the tenant saying, we acknowledge receipt of your letter. Obviously, we disagree with your conclusion. We interpret the lease literally that your rent was due or is due on the first of the month, and any failure will be treated as a default, for which the landlord will reserve all rights and remedies at law and equity and under the lease agreement. Notwithstanding that, landlords are recommended to invite a discussion, non-binding, on some way to get through this time. It won't be binding, but at least you're not just saying that you're going to move for default. I don't think many landlords are interested in moving into default. They don't want empty space. They don't want to try and relet the property in the future. The cost of it, the time of it, the probability of it are all too weak. And with the overwhelming thought and expectation that this interruption will at some point end, and those tenants will be hopefully coming back to their stores, to their offices, to their places of work and business, and begin making money again and begin paying rent. So why disrupt everything for something that might just be very temporary? The tenants, on the other hand, also don't necessarily want to get out of their leases. They don't want to have to look for a new spot. They don't want to have to go through the whole lawsuit to claim eviction or claim a termination right. So I think but they need relief, and that needs to be understood. And the landlords largely understand that if they're not making money, that it's going to be very difficult on them to make the timely rent payments. So when you have hopefully an agreement between a landlord and tenant to enter into some kind of discussion, typically we're talking about a rent abatement, a rent deferral, perhaps a rent extension, allowing a free rent period. A bunch of different options are out there, but those discussions need to be held. And really, what I've been seeing in the last 3 weeks, the groundwork for those discussions changes on almost a daily basis. Something a landlord may have offered last week is off the table. Something a tenant may have tried to offer or be willing to accept a week ago is off the table. So everything is changing. It's very fluid, and I think people are still trying to find their footing on where all this is headed. But I'm encouraged with the level of discussion that's taking place. Landlords are going to start receiving, if they haven't already, and a good number of them have, letters that are from national retailers. I've seen several that they're sending out across the country to all their landlords. And it's the exact same letter telling them we're not signing, we're not paying rent, we're exercising the force majeure under our lease. And they're sending these letters out regardless of what their leases say. Their leases may not even include a force majeure. It may not include a force majeure specific enough to address this issue. It may include a force majeure that says, notwithstanding force majeure, you have an obligation to pay your monetary obligations, your rent. So they're just sending the letters out and inviting discussion, which I think is good for everybody. And be prepared that some of these tenants will not enter a negotiation without a non-disclosure agreement. They don't want it to get out what they're willing to offer, how they're willing to negotiate their obligations. That protects the tenant, but I think in a way it also protects the landlord. Perhaps a landlord doesn't want everybody in its building or shopping center to know what it's willing to accommodate for one tenant versus another. So I think these discussions are already taking place. I think it's a very good thing. And again, we're all finding our footing on a daily basis because things change so rapidly. If you asked me a week ago, I think it would have been a good prediction that everybody would be shut in through at least May 1st, if not possibly heading towards June. News today seems to indicate, and it could change again tomorrow or today, that perhaps certain portions of the business world will be allowed back out again. So no one really knows. But what we do know is at one point people will return to work. So these agreements for deferment, for abatement, do not need to go forever. They are to be temporary in nature, and people are just trying to get their arms around how long does this need to be. Now, when entering into some kind of agreement, the landlord needs to be mindful of its existing costs and expenses on a monthly basis, under which it can accept no less from its tenant base. And these would include the landlord costs of taxes, insurance, operating expenses, and perhaps debt service. The landlord may have some flexibility with minimum rent, base rent requirements, taking half or taking a certain portion of it for a limited amount of time, maybe forgiving it for a certain amount of time. And I've seen landlords offer, we'll abate rent for 3 months on your minimum or base rent only, provided we add on 3 months to the end of the term in 2 or 3 years from now, and you'll pay that rent at a higher amount. A lot of things, it's a lot of freedom of negotiation, and the landlords need to be very careful how they address this because of those overwhelming and continuing obligations they may have with regard to taxes, insurance, and debt service. Well, I think those are the main issues I wanted. I'm just looking at my notes, but I think that's really what I wanted to look at. Again, just to remind people that these are temporary times. We all hope and expect that one day this will be over. We'll learn something from it. But these leases and these contracts will get back into performance stage. People will be back at work again. We did not talk a lot about loan agreements or anything like that. I don't know how much time is left, but just be mindful. There are a lot of trouble with lenders right now. There's a lot of uncertainty in the financing market. I don't know what that means.
7 minutes.
Okay.
7 minutes left.
Thank you. But if any of your clients are still, or any of you, or any of your clients, or any of your the people you represent are trying to negotiate loans with lenders right now, be very mindful in your loan applications. Lenders typically will have a material adverse change condition, which will allow them to terminate the loan application at any time during its review if it feels that certain changes, and certainly I think what we're experiencing now would be claimed by many to be a material adverse change in our economy, the financial markets, liquidity, and everything else. So you don't want to get caught in a situation where you've extended yourself either as a buyer with non-refundable earnest money waiting on a loan without a loan contingency in your agreement, or perhaps having deposited a great amount or getting ready to deposit a significant good faith deposit under a loan application, only to find out that the loan won't be closing at the time you expected, may not at all, maybe not on the terms that were originally sold to you or proposed to you at a certain rate over a certain term. I'm seeing loan applications and loan packages come out that were pre-approved in the first week of March for April closings, and lenders are communicating under a material adverse change, the terms of the loan will change, requiring larger holdbacks, requiring higher interest rates, higher fees and costs along the way. So things are changing out there. Be mindful of that. There's so much focus being placed on leasing and contracts that are in place now. But I think it would be wise to learn from this in the future with future leasing and loans and purchases and acquisitions and even sales, to keep some of these, or put some of these provisions in those agreements. And for a long time, they're largely absent. I don't think we've ever experienced anything like this before. But I think, again, in a lot of your form documents, you're going to see a lot of language now talking about pandemic. You want to see a lot of language in force majeure talking about epidemics, government required business cessations, closures, interruptions. So I think looking forward, there's going to be a lot of change, and we'll address it the best way. And I think the legal industry will too. And I know there are a lot of law firms looking at it right now, and people thinking, what's the best language we can have? And I think we will have good language for it. I think a lot of it's going to be based on experience we glean and gain from what we're going through now.
Yeah, we just added a page to every PPM, loan document, rent lease agreement in the nation. That's the Full Employment Act. So a couple housekeeping items. I closed out the poll. It looks like either there are a lot of attorneys on here or people in Texas speak Latin and knew what force majeure meant before this pandemic. A couple good questions I'll hit, kind of go in reverse order. From a balance perspective, what is a fair compromise as to when deferred rent should be paid? Understanding that paying it back in 2021 might not be feasible. So is it tack it on to the end of the lease, a little bit onto each year, recalculate the monthly? What, in your perspective, are some of the things we could do with lease payments to make them fair?
Well, yeah. Fair is a funny word. What's fair to one may not be fair to the other. Landlord's hands may be tied again with other obligations it has to pay. Taxes, operating costs, debt service, insurance. Those costs aren't going away, and those parties are still holding their hands out waiting for the landlord to pay them as well. There are a number of vehicles out there available to the tenants already, depending on how big the tenant is. The stimulus and I guess it was the second stimulus, a third that was passed, the CARES Act just a couple of weeks back, which is now coming online, providing small loans or loans for small companies. I think it's less than 500 employees, and I don't know all the specific requirements on it, but I know a portion of those funds can be used for rent. I've seen landlords require their tenants, if they're asking for some sort of deferral or some sort of rent slash or cut, to require these tenants to go take advantage of some of those loans, take advantage of some of those programs and relief that has just been passed, and to show documentation they've gone to their banks and obtained it for two reasons. One, it shows the good faith on the part of the tenant. It'll go out and borrow the loan as long. I think there are certain limits and requirements that will allow the forgiveness of that debt, provided all employees are retained for a set period of time. I don't remember exactly how long. So it's money that is available for the very purpose of maintaining employees, keeping payroll, and possibly applying some of that money to rent. If that money can be applied to rent, then the landlord should be entitled to collect it as rent. It's the purpose for which some of that money may be allocated. So when you're calculating how much is fair, you can't collect money a tenant doesn't have, but the tenant still has an argument to say the tenant still has its obligation fully to pay the rent in full. Landlord can accept less, but the landlord can only accept so much less before he's in default or she's in default of other obligations on the flip side. So I think each situation is different. It requires a good faith discussion between the two. And then also probably primarily in that discussion, how long are we really talking about? I think a few weeks ago, people were thinking 3, 4, 5, 6 months. I think those windows are closing down now. I think we're probably talking 1, 2, or 3 months max. If it goes longer than that, then we can have a second round of negotiations. But if it's only going to be for 1, 2, or 3 months, then let's get as much money as we can out of you, realizing you're going to have some startup cost tenant when you do get back to your office.
So back to that, we did a CARES Act webinar this morning, and we'll probably do a couple more. So there is money available for rent. Is it the tenant's obligation to seek that money? And does the landlord have a right to it should they be awarded those funds?
Well, I don't think it's the tenant has an obligation to. I'd be surprised if a tenant didn't. But I think it could be used to demonstrate good faith to the landlord to take a little bit less. That way the landlord's not giving everything up alone. If the tenant has that money available to it under the CARES Act, then why shouldn't it get it? The purpose of the act, at least that portion of my understanding, is for this very reason, to help accommodate some rent payments, keep payroll going for a 2.5 month, 3 month period. I can't remember what the duration of it is. And if that's what the stimulus was for, then go get it. If you're not going to avail yourself, tenant, of those resources to you, then don't come to me complaining that you can't pay the rent.
Okay, we're bumping up against time, but there's a question that came up 3 or 4 times on the chat room on business interruption insurance. I know us as a company, we're in the event business, so we were certainly, our CEO's first thought was, I've been paying for business interruption insurance for a while, so can't I go use it? Have either of you had experience with that yet?
I've not, Scott, maybe you have more on it. I don't get too far into insurance, but I have been reviewing insurance policies from several clients who've asked me the same question. And what's interesting to note is, like any other insurance policy or insurance coverage, there's a declarations page that tells you what your coverage is, and then there are about 50 pages behind it of exceptions, exclusions, and things of that nature, which limit your coverage. Some of the keywords I was seeing and key exclusions and exceptions, one in particular was for viruses. A lot of insurance policies I reviewed specifically carved out business interruption arising from a virus. So I'm not sure how that would really apply here. If there's an exclusion in coverage, does it really happen? And whose policy are we really talking about? There's business interruption, there's rent interruption. Insurance law is a little bit outside of what I do, so I don't want to say anything that's wrong, but my impression is that there's going to be a lot of fighting about that, and a lot of those policies already have exclusions for virus.
Yeah, I would echo that as well. That's not an area that I think at least we have seen so far. I expect there's probably others who counsel who that's a little bit more in their wheelhouse, and I don't. Unfortunately, I don't think I could be able to weigh in on that too much here.
Well, we are plumb out of time. If I'm going to send all of the questions to Scott and David that were in the chat room. It's got your name attached to it. If they have time and are kind enough to respond to that, they'll do that individually. Feel free to send me an email. Go ahead.
Oh, no, I was just absolutely. Okay. Yeah, we're happy to make ourselves available.
We'll get those out, and if people want the PowerPoint slides, we'll be able to get that out to you as well. And this here is reinforcing that we have a YouTube channel. You'll get a link. Probably give our tech guy, Alan, 2 or 3 hours to get today's webinars up on our YouTube channel, but then you'll be able to have the replay and view it as many times as you like. And again, questions can go to me or to Scott or David. I'll put their email addresses up on the screen again real quick as we sign off. If you have questions that we didn't answer, put them in the chat room right now. I'll leave the connection on for another couple minutes, and we'll make sure that we capture those for you. Scott, David, thanks. This was really informative. We've done a couple of these with attorneys. You guys really went into detail, I think, that people are going to find very useful, and it was practical to the point. This is the argument. This is the counter argument. I think a lot of people are going to walk away ready to understand their contracts and obligations right now. Thanks, gentlemen.
Thank you for the opportunity. Appreciate
Thank you very much.
Anytime. Yep. You guys can log out. I'm going to leave the screen on for a minute.
All righty.